I turn now to the issue of offer and acceptance, which is one of the first things one learns at law. And I remember when I was a law student having great difficulty trying to be very precise about it, almost like with a chart as to when the offer is made, what constituted an offer, when the counter-offer was made, and when the counter-counter-offer was made, and when exactly a contract was made. But it's much, much simpler than that. What you're looking for is one party to a contractual arrangement making a suggestion, an offer we call it in law, to another party, which is then unequivocally accepted by the other party. Now, unequivocally, you know what that means. It means without any qualification. If there is a qualification, it can't be an acceptance. That'll be a counter-offer. And so you look simply to see what is it that party A has said to party B. Party A says, I'd like to buy 100 bricks, please. Party B writes back saying, sure, we'll sell them to you on these terms. If party A comes back saying, no, not those terms, these terms, then there's no contract concluded. It's the party A's terms, which he's sending back to party B, which become the counter-offer, and you go back and forth, until finally someone says, okay. And there's no need to have any signed agreement in English law. You can have simply word of mouth. You can say, I agree. It's much harder to prove afterwards, which is why in these days of internet and interweb and galactic, all the rest of www dots and so forth, people feel safer having a written contract which is signed by somebody. They feel safer. But for example, in my own business, I prefer using word of mouth. I don't agree anything in writing with my consultants, and they are that. They're not employees, they're consultants. In case the HMRC are listening to this, they are consultants because we operate on the basis of trust. So it gets more complicated, the issue of offer and acceptance, when one has the internet. Before that, you had faxes. It became a big challenge for the law when a faxed exchange takes place. And for those of you who are younger, faxes were shorthand for what was known as facsimiles, which were a way of sending a document over the telephone to a receptive machine which had paper which could print out a visual image of what someone had written or typed on the sent image. They've now all but disappeared, apart from, I think, small French country hotels still require you to book via a fax response. But that started the change in legal thinking and a need for development as to when it was that a contract was concluded. Of course, internet is something else altogether. And all these things matter because if I'm sitting in Scotland or in Dubai or Alaska replying to your offer of a contract, then where does the contract take place? Is it in, or rather, which law applies to the contract that's agreed? Is it the law of Alaska or Scotland, or is it Dubai, or is it England? And all that will have to come in a separate talk at some future stage. And here we are at the end of episode, whatever it is. Thank you for your time, and I hope to see you again next time. Don't forget, if you wish to subscribe to these talks, click on the button which is either down there or down there. Thank you for your time, and good luck in your studies. Bye-bye.